Imagine a world without contracts. Buying groceries, renting a house, even going to work. These everyday activities rely on agreements. Contracts are the invisible threads that hold our society together. They provide a framework for trust and certainty in our dealings with others. In India, the Indian Contract Act of 1872 governs these agreements. This law lays down the rules for creating, enforcing, and interpreting contracts. Understanding its basic principles is crucial for everyone, not just legal experts. Whether you're signing a lease, buying a car, or entering a business partnership, contract law touches upon various aspects of our lives. It ensures fairness, prevents disputes, and provides remedies when promises are broken. This essay will delve into the core concepts of contract law in India, empowering you with the knowledge to navigate the legal landscape of agreements confidently. At its heart, a contract is a legally binding promise. It's an agreement between two or more parties that creates mutual obligations enforceable by law. This means if one party fails to fulfill its promise, the other can seek legal recourse. The Indian Contract Act, 1872, defines a contract as an agreement enforceable by law. This definition highlights the essential elements, an agreement and its enforceability. Not all agreements are contracts. For an agreement to be legally binding, it must meet specific criteria laid down by the Act. These criteria include elements like offer and acceptance, the intention to create a legal relationship, and consideration, among others. We'll explore these building blocks in detail in the following sections. Understanding the legal foundation of contracts is crucial to distinguish between casual promises and legally binding agreements. This knowledge empowers individuals and businesses to enter into contracts with awareness and protect their interests. The Indian Contract Act outlines several key elements that must be present for a contract to be considered valid. These elements ensure that the agreement is legally enforceable and protects the interests of all parties involved. These elements form the foundation of a legally enforceable agreement, ensuring clarity and fairness in the contractual relationship. First, offer and acceptance. A contract begins with an offer made by one party to another. This offer must be communicated clearly and must outline the specific terms and conditions. This offer must be clear and definite, expressing the willingness to be bound by specific terms. Ambiguity in the offer can lead to misunderstandings and disputes. The other party must accept this offer unequivocally without any modifications. Any changes to the offer would constitute a counter-offer, not an acceptance. Second, intention to create legal relations. Both parties must intend to create a legally binding relationship. This intention is crucial as it differentiates social agreements from legal contracts. Agreements between family members or friends, for instance, might lack this intention and may not be considered contracts. Social and domestic agreements are generally presumed not to have legal intent. Third, lawful consideration. Consideration refers to something of value exchanged between parties. It is the price paid for the promise of the other party. It can be money, goods, services, or even a promise to do or not do something. Without consideration, a contract cannot be enforced. Fourth, capacity to contract. All parties involved must be legally capable of entering into a contract. This ensures that they understand the terms and consequences of the agreement. This means they must be of sound mind, of legal age, and not disqualified by law. Minors, for instance, generally cannot enter into contracts. Fifth, free consent. Agreement to the contract must be given freely and voluntarily, without any coercion, undue influence, fraud, misrepresentation, or mistake. This ensures that all parties are entering the contract willingly. And finally, lawful object. The object or purpose of the contract must be legal and not against public policy. Contracts with illegal objectives are void. Agreements to commit illegal acts or those that harm society are not enforceable. Such contracts are considered void from the outset. These elements are crucial in determining the validity of a contract. They ensure that the contract is fair, clear, and enforceable. If any of these are missing, the contract may be deemed void or voidable, offering limited or no legal protection to the parties involved. Understanding these elements helps in drafting and entering into valid contracts. Section 4. Capacity and consent, the who and how of agreements. Two crucial aspects of a valid contract often overlooked are capacity and free consent. These elements are fundamental in ensuring that all parties involved are treated fairly and that no one is taken advantage of. These elements address the who and how of an agreement, ensuring fairness and preventing exploitation. Without these, the integrity of the contract can be compromised. Capacity refers to the legal competence of a party to enter into a contract. It is essential that the parties involved have the ability to understand the terms and implications of the agreement. The Indian Contract Act specifies that individuals must be of sound mind, of legal age, 18 years or older, and not disqualified by law from contracting. This ensures that only those who are legally recognized as capable can enter into binding agreements. For instance, a minor's agreement is usually voidable at their option as they lack the legal capacity to contract. This protects minors from being bound by agreements they may not fully understand. Free consent ensures that the agreement is reached voluntarily and without any undue pressure or deception. It is crucial that all parties enter the contract willingly. The Act identifies 5 elements that can vitiate consent: coercion, undue influence, fraud, misrepresentation, and mistake. These elements can undermine the validity of the agreement. If any of these elements are present, the contract can be declared voidable at the option of the party whose consent was not free. This provides a safeguard against unfair practices. For example, if someone is forced to sign a contract under duress or threat, the contract is not considered to have free consent and can be challenged in court. This ensures that no one is compelled to agree under pressure. Similarly, if a person is misled into signing a contract by false information, they have the right to void the contract. This protects individuals from deceitful practices. Understanding capacity and free consent is vital for protecting individuals from being bound by agreements they did not genuinely consent to or were not legally capable of entering. It ensures that all parties are on equal footing and that the contract is fair and just. Section 5. A landmark case when consent went wrong. The case of Mohori Bibi v. Darmodas Gose from 1903 stands as a landmark judgment highlighting the importance of capacity to contract. This case involved a moneylender, Darmodas Gose, who lent a significant sum to a minor, Brahmo Dutt, securing the loan with a mortgage on the minor's property. When Dutt failed to repay the loan, Gose sought to enforce the mortgage. However, the Privy Council, then the highest court of appeal for India, ruled in favor of Dutt's mother, Mohori Bibi, who had challenged the validity of the mortgage. The court held that since Dutt was a minor at the time of the agreement, he lacked the legal capacity to enter into a contract. Therefore, the mortgage was deemed void and unenforceable. This landmark judgment reinforced the principle that contracts with minors are void ab initio, meaning from the beginning. The Mohori Bibi case serves as a stark reminder that capacity is not merely a technicality, but a fundamental pillar of contract law. It protects vulnerable individuals from exploitation and ensures that agreements are entered into with full legal understanding and competence. Section 6. Practical tips. Navigating the world of contracts. While the intricacies of contract law can be complex, understanding some basic principles can empower you in everyday dealings. Whether you're entering into a business agreement, hiring a contractor, or even renting an apartment. 1. Get it in writing. While oral agreements can be legally binding, enforcing them can be challenging and often leads to disputes. Always strive to get your contracts in writing to ensure clarity and enforceability. A written document provides clear evidence of the terms agreed upon and can prevent misunderstandings later, serving as a reference point for both parties. 2. Read before you sign. Never sign a contract without reading and understanding it thoroughly. This step is crucial to avoid any surprises down the line. Pay close attention to the terms and conditions, particularly the fine print, which often contains critical details. If something is unclear, seek clarification or legal advice before signing. 3. Negotiate and amend. Remember, contracts are not set in stone and can be adjusted to better suit both parties. You have the right to negotiate the terms of a contract before signing. Don't be afraid to ask for changes. If you disagree with any clause, don't hesitate to discuss it and seek amendments. 4. Keep records. Always keep copies of all contracts you enter into, as well as any related correspondence. This documentation can be crucial in case of disputes or if you need to refer back to the agreed upon terms. It helps maintain a clear history of your agreements. And 5, seek legal advice. If you're unsure about any aspect of a contract, especially for significant transactions, don't hesitate to seek legal advice from a qualified professional. Their expertise can be invaluable. A lawyer can help you understand your rights, obligations, and the implications of the agreement, ensuring you are fully informed. By following these practical tips, you can navigate the world of contracts with confidence and protect your interests, making informed decisions every step of the way. Section 7. Stay informed, stay protected. Contract law plays a vital role in our daily lives, underpinning countless transactions and agreements. From buying a cup of coffee to signing a multi-million-dollar deal, understanding the basic principles of contract law is crucial for everyone. While this essay provides a starting point, remember that laws can be complex and subject to change. Staying informed about your rights and obligations is an ongoing process. Numerous resources, including legal websites, books, and consumer protection agencies, can offer further guidance. By being proactive and informed, you can ensure that your agreements are fair, legally sound, and protect your interests. Remember, knowledge is power, and in the realm of contracts, it can save you from potential pitfalls and disputes.